Discharge and discrimination. These are two huge issues that everybody that studies employment law needs to sit down and pay special attention to. This is kind of like the bread and butter of the really tough stuff that you have to deal with. In human resources, you have about 80% of the job is all the regular routine tasks of the aspect of interviewing people, gathering a pool of candidates, the aspect of actually hiring people, processing the paperwork. But that other 20%, it really gets into the weeds of actually knowing the technical aspects of it, developing strategies, how to make certain that you stay on course, and then when something goes awry, making certain that you deal with it, and then train people so it doesn't happen again. The best part about making a mistake is you can figure out, I made a mistake, and then go back and correct it to make certain it doesn't happen again. Those that sit down there and don't do it and have sloppy work, they will regret it because of the fact that it'll come back again and again and again until you finally get it right, or get the people that are doing it wrong to get it right, or get rid of the people. You need to sit down in these areas. Everybody should be able to come into work and have a safe work environment and be free from being picked on, harassed because of whatever reason it is related to their discrimination. So let's talk about what that means. A tort is a non-contractual civil wrong for which the law provides a cause of action. If you ever get sued, the lawyers are looking for cause of action. They'll be happy to go shopping and try to figure out what you did wrong and list it. And even sometimes they'll kind of stretch the law a little bit to make it fit their case better because, of course, they want to sit down and shake you down for the most amount of money that can fit in their client's pocket. Oh, wait a minute, and their own too. Not that I have anything against lawyers, except for the fact that, yeah, that's kind of what they do. Okay, so they're looking for stuff that intentional and outrageous conduct. Okay, infliction of emotional distress. You will do this work, and if you don't, really bad things will happen to you. Yes. Okay, defamation. Do you know what they said? I cannot believe they said that, but my golly, they really did. Nobody said it. Or, what are you doing again? Why are you doing? Now, by the way, if you're doing at work, here, take a clue. Yes, your employer does have a right to know what you're doing. They have a right to listen in on your phone. They have a right to see what's in your desk. So if you're doing anything, make certain that you're doing things right. One time, I had a superb manager in human resources, and we had a situation where a supervisor was constantly heard trying to take his secretary out to lunch, and he was had a reputation for pursuing things in other places besides the office. I'll let you sit there and paint your own aspect of it. He walked in the office, and she sat there and says, "I want to see your cell phone." What? I want to see your cell phone, and I want to see it now. You can't do that. She says, do you use your cell phone for work? Well, yeah. Do we give you an allowance for your cell phone? Yes. Do you use your cell phone to text people? Yes. I want to see your cell phone. You're having employee communication on your cell phone. I have a right to see it. He hands her the cell phone. He says, enter the code. He enters a code. She found a couple of things in there, and eventually we didn't catch him that time. We caught him about 7 months later, and he was fired because of the behavior. Yes, it was an appropriate invasion of privacy because he's got a cell phone that really, by all intents and purposes, was paid for by the district. So that being said, wrongful invasion of privacy. Federal law in many states prohibit discrimination based on race, color, sex, religion, national origin, age, disability, genetic information. We'll talk about that later, and other characteristics. So that being said, you're looking at all these different things, and they fall under two basic areas of discrimination. And the different things they have in common, we'll talk about disparate treatment and also disparate impact. The two are different, but they sound alike, and they're very similar. So let's talk about them. Before we even talk about them, though, we have to talk about intentional discrimination. I don't like your accent. I don't like the color of your skin. Almost nobody says these things, okay? But the reality is they may act upon them as well. Sometimes you'll have intentional aspects of it. I just really don't like those people. Who are those people? Okay, be careful about what you say. if it happens in a workplace, it's open and it's cannon fodder sometimes for those people who just sit there and speak their own mind because maybe there's not too much going on inside that mind before they say it. Okay, so that being said, refusing to hire somebody because of their race, because they're older. We don't want those old people in here. Yeah, let's treat them like garbage. Yeah, we want young people that can do this. Not that I'm speaking out of any issue about age. No, I'm believe it or not, I'm only 32 years old. Okay, and if you have a problem with that, too bad. Okay, so that being said, promoting somebody other than their qualifications because of their gender, those things really still happen today. I thought my generation would take care of all these things. We didn't do all that good of a job. That's your turn. So with that, let's take a look at a couple things. Unintentional discrimination sometimes happen. When it does, it has a disparate impact. It's a neutral policy or practice, but once you look at the policy or practice, you're finding out you're excluding this entire group of people. How is it that we can't get this group of people here to apply for a job? I got a concern for that because of the following. Sometimes those things happen. I had a situation that was really unusual. We tried to go a long time ago at one college I was at. The committee wanted to hold telephone interviews because it was hard to bring the candidates in. So I'm trying to hire a math professor. And so we had these 15-minute telephone interviews. And I, I let them go and everything in the process because that was brand new. And I found out that of the 10 candidates they interviewed, they eliminated 7 of them from the pool. So I'm down to 3 from my pool. I said, okay. And I read the names. They all had an Asian last name, some type of Asian last name. I said, what's going on here? I says, you eliminate all the Asians out of your pool. And they says, well, we couldn't understand the accent. I said, okay, we're scrapping your program. That's it. What you're doing, you may not have meant to discriminate, but you just wiped out an entire race, multiple races on this whole aspect of it. We're going to scrap this entire thing because you are having disparate impact, whether you know it or not. It's happening because you can't understand the accent. Let's bring them in. So he brought them in, and it might have been strange to them, but really that is a big issue because we're missing some wonderful people in the process. They didn't have a chance to fully compete because they couldn't be seen. All we heard was her voice only. And when you're talking, having all this stuff over here, this nonverbal communication is part of it. Your face is part of it. There's more to communication than a voice. And what the rules say, when you have it's not clear as to what you're saying, okay, that we rely 92.7%. We always round to 93% based upon the study from UCLA in the 60s of all things, and that because of the fact people don't understand clearly the words that are being said, they rely on the nonverbal communication to communicate that. So by removing the opportunity for these candidates to have nonverbal communication, we were creating an environment where Asian candidates could not get a fair treatment on the job because people couldn't see them in action. We paid the money, paid for travel, they have them come physically for those that were out of state, and we ended up hiring an excellent candidate. So that being said, let's take a look at the policy. In the hiring practice, it uses test results that unintentionally eliminate certain minority applicants. I had that going on and I had to stop it. You might have a lending policy if you're working in a company that excludes certain people based on race, or a housing policy. Pay attention to what that is, and you have to be observant because if you don't, that could slide underneath the radar, and all of a sudden you may have the best of intentions and all of a sudden might eliminate an entire pool of candidates accidentally. You also then have disparate treatment. It looks like disparate impact, but you might have a treatment because of certain characteristics. They came in and I didn't like the way they were dressed. Sometimes it's intentional or it's unintentional. The interview process is mediocre on a good day. You need to listen to me on that. We make a judgment when somebody walks in the door, and because we are human beings, We make a decision as to whether or not they're qualified for the job between the first 2.5 seconds to 7 seconds. I'm telling you, that is not fair. And in that process, this person has worked, sometimes they've worked for years getting an education. Sometimes they have a whole history on the resume of hard work, and they want to have an opportunity to be an employee of your organization. And you make a judgment based upon the fact that you like how they looked. They reminded you of somebody who you really hated 3 years ago. They reminded you of your ex-wife. They remind you of this. They remind you of that. Those things aren't fair. You need to have an open mind. You need to create an environment, if you're in charge of this area, where people will sit down and hear you talk and say, you need to wait a half hour to listen to these people before you make a judgment. Push it all aside. And you know what? They are human too. You're a human too. But now you're going to walk out of this class with the knowledge that this happens, and you have to have a wide open mind. And I would hope that if you are in charge of employment law, because this is your turf, then you need to sit down and have that same message go out. We need to have open minds to whoever comes in for the interview, and don't look on the outside. Find out how they problem solve, have them talk, have them sit down and keep an open mind as they listen to make certain that in employment they don't have disparate impact or disparate treatment in the process. On treatment, sometimes if it's a class underneath Title VII, you pay attention to that. If they apply for a job or qualified, okay, what are they looking for this aspect over here? Did you miss this person in the process? One time I had a job posting. We posted it for a part-time job. It was the middle of a recession and people were scrambling for work. It was a 19.5-hour job for a child care assistant. I had 966 applications for it. I didn't want to hire, I just wanted to hire one person to work part-time, half-time. Well, we had to sit down and go through a weeding process as to how to reduce 966 applicants down to a pool that you could interview. Normally, you don't want to have any more than 10 people. You try to really have about 6 to 8 people to interview. How do you squeeze that down? It was difficult because we had a lot of candidates that were far overqualified for a lower level paying job like that because the economy was really difficult in that moment. So pay attention, look for candidates, make certain if you have something funny going on and you sense it's funny, feel free to go check, grab the applications and see why certain applications were rejected from being interviewed or in the interview, and see if there's something there. If you feel there's an issue, go check it out. You don't know until you know. Defense, I included defense here. Did you see defense? That's a defense. Okay, so make certain there's a couple things. You have a legitimate non-discriminatory reason, an LNDR, for actually having this action over here. I need to have this person over here, and I only had 3 candidates apply for them, and they were all white. They were all Latino. They were all Latinx. They were all this. They were all this. Sometimes you need to get them, and so you may exclude other groups because you have a teeny tiny pool. Is probably the only time I have ever used this, and you're desperate to get somebody in that job and you need it filled almost immediately. Sometimes you have a pretext for it and somebody makes up a reason. Oh, we searched high and low, but we couldn't find anybody. Well, let me see how many places did you really advertise? Well, we only advertised in this magazine. Well, who reads the magazine? Well, only about 500 people do. Okay, I'm sorry. I'm required by state law that I have to go and post it across the state. We're going to use the following things over here. Oh, and miraculously, you get all kinds of candidates. They wanted to hire their nephew or a relative. Oh, that never happens. Yes, it does. So make certain you're having appropriate aspects of it. There's also we call it a BFOQ, a bona fide occupational qualification. Put this one in your notes. It's permissible discrimination if it's based upon the employer's business over there. The illustration that they have in the book and everything else, it's a bit embarrassing. They're talking about Playboy bunnies and Hooter girls. You know what? If I applied for a job as a Playboy bunny, I'll bet they would exclude me because I don't have the bona fide occupational qualification for the job. I'm going to let the discussion just stop there. Let your imagination go wild if you want to. But a BFOQ, sometimes you will have that. Sometimes you have a job, especially a heavy lifting job, and you may have to have somebody picking up steel to move it from one location to the next. And it could be that it'd pick up 50 to 75 pounds and put it on top of a forklift truck. If that happens, you may want to have a physical test on it, and it's possible you may only have a pool from 50 people and you weed it down on a test that relates to the job, okay, down to 5 people, and they all happen to be one gender. Okay, so sometimes a BFOQ will happen, depends what it is. So know these things for this aspect. A tort, non-contractual civil wrong, discrimination, two types, disparate treatment, I guess there's three. Technically, there's also deliberate discrimination on top of that, and a BFOQ. Take care.